This is Duke University.
Very good. So last but not least, there's 6 of us. Everybody's remarking on how well organized and planned this conference is. One sign of that is sort of the balance. I don't know about ideological balance, but each panel has 6 people, and that's a certain amount of balance. This panel only has 1 paper, so what this tells you is that one of the 5 of us didn't write our paper, and only Neil knows who that is. But in any event, it gives Ted the benefit of I don't know if that's true or not. I didn't write one, but the benefit of more feedback. Which
you didn't write one?
So where is that 8th paper? I don't know. So in any event, it's also somewhat of a different panel in that, well, with 4 commentators, we have more ground to cover, and for that reason, we want to open things up beyond the strict confines of the paper, which focus principally on federalism. As the title for the 4th session says, we're going to broaden the discussion out to basically anything you want to say about the enduring problems of the American healthcare system. And so, appropriate to that, we have a breadth of expertise on the panel. I won't go through people's backgrounds, that's covered in the bios, but suffice it to say that Abby and Gillian are experts in federalism, and Barak and Arti are not. They, however, are experts in health policy, and Ted, uniquely, I think amongst just about everybody in the room, is an expert both in constitutional law and in healthcare law, and so it's appropriate that we end the day with his views. However, I think the sort of the litany in the previous panels has been to recite the title and then note that both points of the title of the paper are well addressed. Here, in this case, the title is Icebergs and Glaciers. I didn't see anything about either icebergs or glaciers in the paper, so I'm not quite sure what. I word searched, I found the word iceberg.
Iceberg is there.
I never found a glacier. So,
it's a slippery slope argument.
So my first question to Ted is, glacier, the slippery slope, what is the glacier? I assume what he means is obviously the iceberg. There's a lot submerged below the surface that we can learn about federalism if we look more deeply. The glacier, I assume, is that things actually aren't changing as rapidly as we think they might be. They're moving at a very sort of glacial pace. Is that they hill forms?
Yeah.
Maybe that's
add something.
Consideration.
It's a very rich metaphor. I'll resuscitate the glacier. The ice age.
But what I like most is the historical work that he's put into this. He brings first a non-constitutional perspective on these principles. I mean, appropriate to the afternoon. It's we talked about sort of a popular constitutionalism, and he uses the phrase a legislative constitutionalism, and the idea is that the Constitution is more than simply what the court enforces through doctrine. It's what the legislature itself, what Congress itself decides are the appropriate principles to abide by in terms of constraints on its own authority and appropriate public policy. And so he maps out 2 domains for sort of constitutional, congressional self-restraint in honor of constitutional type principles. And one has to do with individual rights and the other has to do with states' rights, and hence the federalism. The point, I think, on the individual front is traditional legislative respect for individual choice in medical care. And we see this in a variety of ways in both state law and in federal law. And it's very appropriate that Clark is here because, I mean, when Clark is having hers in the side there, it has first taught me and many others is that this respect for individual choice is really an expression of a protectionist attitude towards medical professionals. And so we see, built into various federal laws, this sort of medical professional protectionism motivate or justified in terms of protection of individual choice, but one has to be somewhat skeptical, I think, of the motivation there. But in any event, Ted does a great job of documenting, these instances of Medicare, FDA regulation. He really even pulls up the Hill-Burton Act, which impressed me because I hadn't read that in, 25 years, and it turns out that the Hill-Burton Funding Act for hospitals also has one of these reflexive mantras about not interfering with medical practice and the like. I guess what I'd like to ask Ted to do is explain a bit more about how that relates directly to the ACA. I'm sure these questions of sort of professional protectionist attitudes towards professionalism manifest in some fashion, but I haven't seen that more fully developed. And he promises to develop the Federalist points at the end of the paper, but I'd like to see the individual choice points developed as well. But with respect to federalism, what I learned the most about from the paper is Ted's terrific history of debates a century ago, two centuries ago, about federal authority over public health measures. And I think this is very helpful in a number of different ways. But one is that I'll say in part of my own thinking with regard to the slippery slope question that I like to point out that we need to be concerned, and Elliot addresses this point in his paper, that we need to be concerned not only about the slippery slope, but what I like to call the insurmountable obstacle, that if we set a precedent saying that Congress authority can't be used to mandate behavior, then what would happen if we really needed federal authority to mandate a variety of behaviors relating to contagious disease or bioterrorism or the like? And traditionally, those sort of more mandatory public health measures have been exercised by the states, but I think it would be an excellent example of where we're sort of waiting for each state to act in sort of emergent conditions of a pandemic, avian flu type of situation or bioterrorism would certainly call to mind an instance of where federal action might be needed. And so this is my own thinking, not Ted's, but the point is that developing sort of more clearly the constitutional basis for federal public health mandates, I think could help fortify the case for mandates being part of the general panoply of Commerce Clause regulations. So with that in mind, I was quite interested to read that this issue was debated from the earliest days of the Republic, that we had the likes of Adams and Jefferson going to Congress and saying, you know, we really need to have a federal quarantine law. It's not enough to let the states deal with this, that the ravages of the yellow fever and smallpox and the like are more than our states and localities can handle. And that being debated in terms of public health. And what Ted recounts is that Congress consistently refused to do this, or it would put something in place and let it expire a few years later, because the feeling is that that's really a territory more appropriate for the states. And so you have this sort of, on the one hand, he makes the point that you have this sort of legislative self-restraint with regard to state prerogative, but what I want to highlight is that at least the recognition that it was, at the time, at least a debatable issue, and in some instances an issue on which Congress actually acted. Particularly like the item on page 14 where Ted digs out a dictum from an 1886 case in which the court sort of chastises Congress in passing. It was a challenge, it was a liberty, substantive due process type liberty challenge to a state quarantine law, but the court went out of its way to say, well, this violates no state rights because, of course, it would be perfectly fine if the feds would do it. In fact, we wish they would, because these problems are getting out of control, and we have these unchecked contagious diseases, and nobody's stepping forward and doing something about it. So, scolding Congress for not dealing with the problem. Neil has some good footnotes where he quotes Justice Scalia and Justice Kennedy, I think it is, in some oral arguments saying, well, sort of hypothetically, it would be an easy case, of course, to justify congressional, it was a vaccination or quarantine laws, something to that effect under the Commerce Clause. That's a no-brainer. So there you have it. I think an interesting sort of alternative perspective on the issues in terms of how radical it really is to think in terms of a power to mandate behavior under the Commerce Clause. Realizing the Commerce Clause is essentially the only basis that Congress has to deal with public health emergencies. All right, so that sort of mixes my thoughts in with sort of a quasi-introduction to Ted's paper. And with that, let me turn things over for Ted to sort of put things in proper perspective. Oh, one last word. Ted does jump sort of fast forward 200 years to the present and has some very interesting sort of underdeveloped ideas at the end about how federalism really does work itself out through the ACA. One point that he makes, which was news to me, maybe others already knew this, is if you look at the issue of sort of simply the size of government, we think of federal government being the bloated government, but in fact the number of federal employees has remained steady over the last, what was it, 15 years or so? Or
50.
50. Whereas the number of state employees is what, quadrupled or something to that effect. And so really the sort of the amount of activity conducted by government is grown exponentially at the state level and held steady at the federal level. And so that's an interesting factoid to get. So it's chock full of little tidbits like that. And so I look for the fully developed version to come forward. So
thank you, and I'll respond briefly. I did want to amplify what Mark said. It's the last panel of the day. There's only one paper. We've got a range of health law and constitutional law experts, both on the panel and in the room. And so I encourage and invite leaving the paper behind at some point. But I'll say a little bit to answer some of Mark's perceptive questions in summary. First, on the title. This is the Perils, a very well-organized conference, so well-organized that we were asked for a title long before I wrote the paper. I think, so I sent the title in. Icebergs and glaciers do appear, although in somewhat trivial fashion. So the iceberg metaphor is a bit trite, but it does reflect the basic theme of my paper, which came out a bit in the last panel, which is that the visible high salience debates over the mandate that are taking place in the Article 3 courts today relate to, overlap with a set of values and contestations and perceptions about the proper ordering of authority in American healthcare, a kind of diffuse ordering that will continue to recur and indeed present, I would argue, a much more difficult, durable, bigger barrier to necessary reform than this little skirmish over the individual mandate. Where do those structures come from? And here's the glacial point. And Mark, it does appear in tiny fashion on page 5. Once. It's my fault. Once. But so how is it glacial? It's glacial in two senses. First of all, the pace of health reform in the U.S. has been quite slow, and I can say a little more about that. The paper says a lot about that. We are, despite efforts throughout really the 19th century, as I show, to at least have incremental federal health laws, and then through the middle and second half of the 20th century to more robustly regulate health reform is kind of a parvenu field of federal authority and stands as distinct from many of the New Deal bureaucracies. But it's glacial in a different sense that I think matters more for this kind of normative culture that embraces the current organization of medical care. It's glacial in kind of the sense that a sedimentary sense that even after glaciers recede, they leave behind a topography in place. Now, the metaphor there applies to my view of the way that this traditional authority structure in medicine has been constructed over the past 2 centuries. This is an authority structure which even today prioritizes individual physician and patient discretion at the bedside in the allocation and choice of medical services, funded then usually by third parties, which itself is a problem, but yet the basic authority model to date remains. If you go back 50 or 100 years, this authority structure was really locked in place by a series of licensure rules, common law structures, institutional ordering. So the standard of care then and now in medical malpractice is really, there is no single standard of care that's kind of thin sliced into locality rules and 2 schools of thought, such that doesn't provide any standardizing influence to constrain physician discretion. State licensure regimes then and now are weak forms of policing physician autonomy at the bedside. Moreover, healthcare's development 100 years ago reflects a clear clear legal intervention to trump the normal operation of market forces. And here I refer to the predictable development of large institutional healthcare, which was disabled for much of the first half into the second half of the 20th century by rules against institutional employment of physicians and things like that. Mark and Clark have both written extensively about those rules. So what we have here on the private law side, as well as the kind of failure of Congress to act and failure of state legislatures to do much more than pass authority over physicians off to the doctors themselves, you have kind of a state of play that coalesced about 30 to 50 years ago of kind of dramatic diffusion in medical authority, and a serious absence, not just of public control, government healthcare, but also of private institutional control. Now, the story is more complex in the last 30 years or so, as both public and private payers have tried to impose some restriction. But here's the Glacier point, is that even as those hard legal rules that would disable institutional control have evaporated, and in most states they have, the normative culture of physician-patient, deeply rooted values that is often translated into political debate and or opposition to private reforms like managed care remains very salient and remains a very salient block to what I view are necessary health reforms. I mean, to put it bluntly, one of the reasons our healthcare system is so expensive, yet still fails to cover everybody and still has quality concerns, is that we haven't done a good job of bringing best practices and optimal standards to bear on physician practice. And many of you here have read and authored studies about a variation in practice patterns and the related cost and quality concerns. So these are the structures that are left behind, and in that sense so health reform then is glacial, I say, not just in the pace of change, but also in these deep residual structures which remain around. Now in other writing, I'm not going to push the point here, in other writing I've called this, and I call it here in the paper, the submerged constitution of American healthcare. It's clearly small c constitution. It's very different than our doctrinal or textual constitution, and Jack stepped out, but I'll just say to the room, I don't claim any transference, or I don't argue that judges can or should take a straight line account of this traditional authority structure in medicine and kind of convert it into doctrinal constitutional law. However, there's clearly an overlap in the underlying values such that the ACA litigation, which plays out in the vernacular of canonical constitutional law, kind of presages and predicts forms of opposition that we can expect over the next 10 to 20 years as cost control imperatives require public, state, and federal, and private payers to exercise more control and restriction on the provision of care. And I mentioned public and private players. There is a way in which this constitutionalism and this authority structure is more pervasive and more deeply rooted than canonical constitutional doctrine, is that it doesn't have to play by the rules of the courts, meaning there's no state-federal distinction, it doesn't matter. This is going to operate whether it be some state agency that tries to standardize care or tell doctors and patients, this much is too much, and as well as the feds. And it will and has operated as to private institutional forms of restriction and control. And we saw that distinctly when I was in law school in the mid to late 1990s, or middle of the 1990s, when managed care was at a kind of a high water mark. It actually did succeed in flatlining the growth of medical costs for about 3 or 4 years in the middle of the 1990s. And then the managed care enterprise collapsed at that time due to vigorous patient and physician opposition, more so than any direct federal intervention, for instance. So these battles are all going to recur, driven by the necessity of cost and resource constraints and things like that. And this authority structure is going to exercise a deep oppositional sway. And I say, to describe it, I don't normatively endorse the diffuse structures of American medicine. I mean, there does need to be some reordering. But I do think it's very sticky, and it's going to make reform very difficult, whatever specific form that reform takes over the next 10 or 20 years. I need to quickly say something just about federalism. Yeah, you actually, Mark, you know what?
What's that mean again?
Let me just stop, because Mark summarized the federalism well. I'm not going to say anymore, except how does it relate to the ACA? I don't argue any direct doctrinal control or payoff, but I do think the ACA should be viewed in the 200-year tradition of healthcare federalism, where the federal government regulates rarely, and when it regulates, it tends to defer and or shift regulatory primacy to the states. And the ACA is very much a state-centric statute that carries with it a federalism burden on the states, a huge imposition on the states to implement these new things. It also carries with it a certain consistency with American federalism on the dimension that we can predict, and HHS has already signaled, that states will have dramatic variation in how they implement these exchanges. And so this is a statute that is not monolithic. The states are the key players in this.
Great, thanks. So, well, Abby Moncrieff has been writing about just these things, and healthcare in particular, and so great segue to, I assume you're going to pick up on the federalism theme, so.
I will. Mark introduced me as a federalism expert, and then said that Ted was the only person who does both constitutional law and healthcare law. I'm not sure that I'm an expert on either thing, but I do both federalism and healthcare, and so just to.
I mean, and wrote his paper.
Yep.
So.
Sorry.
and wrote his paper. I meant all three things.
And wrote it. Okay, sure.
But she could have.
I could.
Not that
Clearly,
I'm calling you out.
no. Okay. So no. But I want to focus on healthcare federalism, abstracted from the constitutional debate first, and then try to bring it back to the constitutional debate. So if we take out the doctrinal questions about the limits on federal power, and we just ask, who would be better at regulating the healthcare industry in the United States, the federal government or the state governments? The answer clearly to me is the federal government. So I wrote a paper that has the subtitle, The Federalism Failures of the ACA, and the argument was not that the federal government had taken over too much power, but rather that it had taken over too little power in regulating health insurance markets. So why? Well, health insurance is something that benefits a lot from economies of scale. The more people you get into a risk pool, the cheaper it's going to be to cover each individual, and the more efficient the entire system is going to be overall. So the more that we can get risk pools to extend across state lines, the better off we'll be. And under the current system that the ACA preserves, insurance pools remain largely state-specific. So we end up with insurance pools that are limited not only to employers in a lot of cases, but also have to be limited to states, and it limits the ability of insurers to pool risk across state lines and to get more people into risk pools. So just from a perspective of what's the best regulatory authority for making insurance as efficient as possible, the answer, I think, is clearly that the federal government is better. Now, that same argument and similar arguments can be made with respect to a lot of other areas of healthcare regulation. Since we're focusing primarily on the individual mandate here, I'll limit myself to that observation about risk pools. But suffice it to say that we can say similar things about lots of other areas of healthcare regulation. The second thing that's important to note about purely functional federalism, setting aside doctrinal federalism, purely functional federalism, is that the federal government can capture a lot of the advantages of state regulation, but the state governments can't capture the same advantages of federal regulation, at least not nearly as easily. So the federal government is capable of passing a statute like the ACA that incorporates a lot of state diversity, a lot of opportunities for voice and exit, and all of the things that we like about having state control by granting waivers to the states, by allowing for innovation through demonstration projects that are run in individual states or in individual communities within states, and things like that. So we can get voice, diversity, experimentation, exit, and all of these things out of a federal regulatory structure. But it's much harder to get uniformity out of a state-based regulatory structure. And it's much harder to prevent spillovers out of a state-based regulatory structure. So shifting authority to the federal government for things that are complicated can be a really good way of optimizing the efficiency of a regulatory regime, and particularly for something like healthcare, where there are spillovers and where we do benefit from economies of scale. It makes sense to give some authority to the federal government and to have the federal government then try to replicate the advantages of state regulation to the extent that that's beneficial. Okay, so if that's so clear, then why is there so much resistance to federalization, particularly of the individual mandate? Part of the reason is, and I think Ted makes a great contribution in saying, there's this huge history of professional self-regulation, of freedom and liberty in healthcare autonomy and making decisions about medical consumption, and this looks like a much bigger imposition on that liberty interest than state control, perhaps. Perhaps Massachusetts passing an individual mandate looks a lot less problematic than the federal government passing an individual mandate, because we can be confident that all of the citizens of Massachusetts, or at least a majority of citizens in Massachusetts, wanted that, but we can't be confident that a majority of citizens in Texas wanted that imposition just because the federal government passed an individual mandate. So there's this libertarianism plus federalism argument that's being made here that seems to be driving us back towards more state regulation. So the question is, in my mind, whether that particular problem or that particular concern, if what we're worried about is that we want diversity or voice or something of that kind to be important about, and medical autonomy and the ability of individuals to make their own choices about medical care to be incorporated into the regulatory structure, does it make sense to force devolution back to the states of the individual mandate question through Supreme Court intervention? Or can we trust the federal government to, through political safeguards or through this submerged constitution that puts limits on what the federal government has been able to accomplish, or something like that, to be able to take account of that liberty interest and the divergent views on healthcare autonomy that exist among the states? And again, this is the other part of Ted's paper that I really like, is to say that the federal government already does quite a lot of this. The ACA is not that much different. HHS has already announced that it will give waivers to states to allow them to have some out on the parts of the ACA that they don't like, perhaps including the individual mandate. And so at that point, the concerns about federalism and liberty that are being expressed through the ACA litigation seem somewhat overblown in the context of what healthcare regulation looks like and what healthcare regulation in an ideal world would look like if we weren't worried about constitutional constraints or Commerce Clause constraints. So again, this is a perspective that's largely divorced from the doctrine and is intended to be largely divorced from the doctrine. But the idea is that the federal government is not this overbearing, evil entity that is forcing uniformity on everybody with respect to every aspect of healthcare decision-making. It is an entity instead that is deeply concerned with autonomy in medical decision-making and with professional self-regulation, and is deferential to professionals in the medical context. And so the notion that we need some kind of Supreme Court backstop here is certainly not meritless. I don't mean to overstate the claim, but it's a little bit overstated, I think, compared to what the history of medical regulation has been. I'll leave it there.
Okay. So, Gillian, do us health policy types make sense about federalism?
Well, I was going to begin by underscoring the point that there are lots of health policy experts on this panel, and I'm not one of them. I do think, though, that where I come at this particular panel is not just from a constitutional federalism point of view, but from an ad law point of view, and I think that's an interesting perspective here. I actually thought this was a great final paper, both because, Ted, of the way so many of the themes that have come up already, your paper resonates with, but in addition, because it does actually push us past the narrow terms of the individual mandate debate. And I really share your view, and it sounds like Abby's view as well, that many of the most interesting and challenging federalism issues with the ACA lie elsewhere than the individual mandate. They lie in how this very complicated cooperative administrative federalist scheme is going to work out. You've got states incorporated in federal regulatory structures in a lot of interesting ways. I mean, some that are somewhat familiar in terms of Medicaid, some that are new in terms of the health insurance exchanges, but maybe akin to some forms of environmental cooperative federalism in some ways. Some that are, I think, even more different, such as the deference to the state insurance commissioners in terms of rate review, and then the federal government is a kind of second step on that. So there are very interesting state-federal relationships here that need to be worked out, and the waivers will be also quite interesting. One thing I just want to flag at the outset is that this isn't unique to the healthcare context, right? We're seeing this in financial regulation, we're seeing this in immigration, we're seeing this in national security, we're seeing this in education. Exactly how we're going to work out these state-federal relationships in regulatory schemes is a central cross-substantive issue, and many of the Obama administration's signature policy moves have actually been incorporating state governments in very fundamental ways and rethinking the state-federal policy administrative balance. That does set up a challenge. I mean, I tend to think there's actually a big potential for a really meaningful state governance role, but it's certainly not a clear-cut win for the states for many of the reasons that have been mentioned, right? There are some very significant obligations and burdens that are put on the states. There are also some significant resources and authorization for state regulation that comes along with that. So there's certainly potential there. Exactly how we're going to work out the lines, whether this is going to turn out to be real state empowerment or whether it's going to be more federal co-option, how we should draw these lines, how we should think of the federal and state relationships in these combined regulatory schemes is much messier than the straight-up Commerce Clause challenge, but it's also much more interesting, and I think really honestly much more where federalism today is going. The one thing that I want to talk about, though, a little bit first is the relationship between working out that scheme and the constitutional challenge here. And one of the things that I think is interesting, I think the recent HHS rules are very interesting for this, is having the constitutional and political battles going on does exert some pressure on HHS and the administration, how they actually implement this. So even if the straight-up challenge that we're focused on is somewhat divorced from the reality of where real implementation lies, I think that it's not surprising that we got very flexible rules from HHS about the exchanges, that there will be very flexible rules about waivers. I'm not sure whether one calls this a political safeguard or a legal safeguard, but I think it's a safeguard. I think it's quite interesting how that dynamic is playing out, and I think it says something about how constitutional law works out in our political and administrative world. I also think that evoking federalism and evoking federalism expressly is going to be very important, but not necessarily through constitutional law relating to the under-enforcement point that came out in the last panel. I've written elsewhere about how administrative law, in many ways, I see as becoming the new federalism, that administrative law is one area where we're seeing account being taken of these complicated roles. Other people have talked about statutory interpretations playing a similar function. And these aren't just checks on federal overreaching, they're actually efforts to reorient how administrative agencies might approach some of the questions that they're confronted with. This is coming up in preemption as well. And so ensuring that there is actually express consideration of federalism in these other diverse legal contexts or sub-constitutional law contexts, I think is quite significant. I also just want to say just one or two words. I have no idea. Do I have one or two minutes?
Yes.
Okay. Yes. Just on the history, because I thought the history here is really interesting of the quarantines and of the greater willingness of the President and the Supreme Court to assert a federal role. One of the things I think we see there is that Congress was probably a better representative of the state-centered federalism of the era than the President or the Court at that point was, although the Court obviously changed at different times. The other thing, though, that I think that history flags is the very important role that interstate relations and the Dormant Commerce Clause have played in federalism debates. And that horizontal federalism role has been, I think, overshadowed. Certainly has been overshadowed today in our discussions by the vertical federalism, the federal-state interactions. But initially, federalism was much more about state regulation, interstate relations, state barriers to union, not federal overreaching. And it's not, first of all, in that context of overseeing relations between the states, the central role of Congress, I think, is clear. And I think you see that in Article 1, Section 10. You see it in Article 4. And it is reinforced in terms of the kinds of powers we might want Congress to have. I think it's also interesting because the choices for the court were more limited, right? So the court employees. For that to work, you have to include the private federal workforce. One of the dynamic trends has been a tremendous expansion in privatization because of limits on how much the federal agencies can employ.
So, quick note before, on that last point about the regulatory gap, I can't believe we've got this far into the day discussing federalism and haven't said the word ERISA. So, I just wanted to say the word ERISA.
I'm sure Barak will, and I will as well.
Okay, good. Reminding us, the electoral comment, that up until, just a few years ago, or maybe this year, federalism principles in health policy were entirely accidental. They accidentally emerged from ERISA without any congressional purpose whatsoever. So at least we now have purpose of federalism, which is a very nice change for us. So our next speaker hasn't been previously introduced and hasn't been here today, the next two, and so I'll introduce our next speaker as the other Barak Richman here of Duke fame.
All right. That's right. Okay. I'll be brief. So I would like to say two introductory comments and then one comment on the paper. The introductory comments relate to two rhetorical battles that we've lost. One rhetorical battle that we've lost was referenced when Steve said, "Why are we here?" and Jack Balkin said, "This popular constitutionalism has has created this conference." And I see that as a rhetorical battle we've lost because there are an enormous number of very powerful brains in this room. And if I had my choice, those brains would be focused on trying to solve the nation's health problems and not on debating the constitutionality of this one proposed health solution. The problems are really enormous. The House is on fire. We have to really focus on what I think is as big a national priority as there is, which is trying to figure out a way we can reduce the cost of healthcare, expand insurance, and while we're at it, improve national health. We spend about twice per capita that of number 3 OECD. Number 2 OECD is a little bit higher than number 3 OECD. We have mortality rates that are about 35th, 36th in the world. We have morbidity rates that are even higher. We're not doing well. And it's a severe problem, not just because we have a really unhealthy population, but also because the money that we're spending on healthcare is bankrupting the nation. Bankrupting the federal government through Medicare, and bankrupting private. We're spending about 18% of GDP. A lot of that is preventing the formation of businesses, the hiring of workers, and it is really a significant drain on the private sector also. So one rhetorical battle we've lost is that we're talking about the constitutionality of one proposed health solution, whereas we really need to think of a better solution. And that relates to the second rhetorical battle that we've lost. We are debating the constitutionality of the Affordable Care Act. And this is not the Affordable Care, at least I don't call it the Affordable Care Act. That's too Orwellian a term. Maybe this is the Patient Protection Act or the Physicians Protection Act, the Insurance Expansion Act, the Hospital Subsidization Act. There's nothing affordable about health care currently, and this bill does nothing. It does a lot of really good things, I think, but it does nothing to make health care more affordable. And I actually think that that's probably the priority, much more so than some of the things that it does do. We are kind of behind the 8 ball already. We're focusing on things that I think are less important, and we are, you might say there's a certain power of words. that has caused us to focus on things that I think are really should not be the academic priority. Having said that, we have a paper to comment on, and I think Ted and I have had this exchange before. So this is the comment I have of the paper. It's kind of the debate between the anthropologist and the economist. The anthropologist looks at a complex society and understands all the endemic institutional forces that create the society the way they are, how they've been slow to develop and very slow to change, and they've ossified significantly. And the economist says, well, what happens if I just increase the price of this? What kind of behavior are we going to change? I think Ted is the anthropologist, and I think we need to at least have an economist in the debate. Ted looks at 200 years of history and sees very deeply ingrained authoritarian structures, deep residual institutions, a constitutionalism, shall I say, with a small c, which is his word. He borrows it from other people. That really defines a lot of our dysfunction in the healthcare system. And the counter-argument to that, it's an empirical question, but the counter-argument is, well, what if we changed a couple small rules that change the incentives for both providers and healthcare consumers? Would a lot of that dysfunction evaporate? Or better yet, would a lot of these institutions that we've seen for 200 years evaporate? That would suggest that the institutions are here not because of history, but because of political economic forces. It's the forces that benefit from the institutions are the only ones that are sustaining it. So specifically, this is from the email I sent you a couple months ago on a similar project, just so I make sure I don't contradict myself. Ted.
Yeah.
You have to confront the economic determinism argument. What if we took away the tax exclusion? Let me actually explain that for a second in case, for those who aren't kept up at night because of the tax exclusion. So the tax exclusion is this. When we get health insurance benefits from our employer, we have an employer-based system predominantly in the United States because of the tax exclusion. When we get health insurance benefits that our employer pays for us, those are benefits that we get that are not taxed. So that means that, of course, we're all incentivized to get insurance through our employer, but we don't really see how much the employer is paying on our behalf. However much the employer is paying on our behalf are dollars, dollar for dollar, that is taken out of our take-home paychecks. So the average insurance premium for a family of four in the United States is about $11,000 a year. Most co-payments, premiums, a part of the premium that the employee pays averages around 20%. So 80% of $11,000, I don't know, what is that? $8,800 or something? Is that right? Is dollars that are taken out of our paycheck that we don't see. So what does that mean? That means that individuals are not they don't know how much they're paying for health insurance. In fact, actually, at a recent faculty forum, I asked everybody, how much are you paying for health insurance? And nobody had any idea. And it's a purchase of $11,000 a year. It's something that if you knew how much you were paying for, you would be very cost conscious. It would be an expenditure every year that you would pay great attention to. So, because we had the tax exclusion, not only is there some kind of inherent subsidy because we're not taxed, but also we're just not exposed to the prices at all. So, what if we took away the tax exclusion and thus workers would see how much take-home pay they're losing from rising costs of health care insurance? Would they still act the way that they do as voters? There's a strong reason to believe that the politics are as they are only because the economic costs of physician autonomy are being hidden from consumers / voters / insurers. Forces that now appear to be constitutionalized would wither if exposed for what they are. I think there's a reason that economics as a predictive science has been an empirical victory. And I would think that a lot of these historical creations, historical institutions, would in fact not survive the power of economic incentives.
James Carville said, it's the economy, stupid. Right? Anyway.
It's the incentive, stupid.
Got it. All right, so Arti, Barak, fresh from the Beltway, is going to tell us how it really works in Congress, or in
So I will begin with two disclaimers. Well, one disclaimer is obvious. I don't do federalism, although I do administrative law, which has a federalism component. And I no longer do health policy for many of the reasons that Barak just launched his tirade, I got so frustrated.
Is that bad?
Yeah. I got so frustrated about 8 years ago with what I considered a completely dysfunctional political economy of healthcare that I stopped doing it. So all that said, let me go ahead and proceed and talk about the paper. And I think actually some of the reasons for my frustration are a little bit different from Barak's, and they relate nicely to Ted's paper, I think in interesting ways. So I agree entirely with Ted and with many of the panelists here that the current debate over the ACA is really, I mean, to call it the tip of the iceberg, I mean, these formal constitutional questions, I think, are virtually irrelevant. And so I am very excited that we did have a paper on certain trends towards, or a description of the submerged constitutionalism. So you describe in the paper trends towards decentralization. I think two of the trends that you describe, or the historical tendency towards decentralization, whether it be towards individuals or doctors or states, are fairly well documented in the literature. So the therapeutic individualism of our society, which I think is relatively exceptional, at least relative to the UK, where Jamie's from. So that would explain his comment. So it's a therapeutic individualism, but towards a positive right. So it's a one-way ratchet in terms of cost as a consequence. And, of course, the aggressive desire on the part of the medical profession to self-regulate. Although one thing that I thought was interesting about your paper was that that aggressive self-regulatory kind of elite didn't really come into operation, at least if you believe Paul Starr, until the 20th century. So was there any political economy explanation for congressional self-restraint in the 19th century? I think there was a huge political economy explanation for congressional restraint in the 20th century, which is the AMA. But was there anything like that operative in the 19th century, or was it just Congress deciding that they wanted to be self-restrained, which I find a little bit interesting, but it's possible, I suppose. In the 20th century, I think it's pretty clear that there was the interest group explanation. So, but I think it's really, if it is the case that Congress was just restraining itself voluntarily, that's very interesting. And it may have also to do with the relative absence of the administrative state at that point. Perhaps this was something that was somehow related to the relative absence of the administrative state. I do want to tell something of a counter-narrative, though. And that relates to work I currently do, and also relates to some of the things that Barak was talking about. There's been an incredible rise, as I suspect you know, of a federally driven medical industrial complex post-World War II. So 1/3 of all biomedical research is federally funded, almost no state presence there whatsoever. The rest is private sector. There's a very generous intellectual property system, a very generous regulatory system at the federal level, and all of that is entirely federal. Intellectual property, which is what I currently do, has virtually no state component to it. So on the supply side, we have a very centralized system. On the demand side, less so. And so what happens when the supply side meets the demand side? So we have a very strong centralized supply side on the medical technology side, with, I think, accompanying interest group pressures to expand and expand and expand. On the demand side, there's less explicit centralization, but we do have the tax subsidy, which keeps the costs of all this medical technology invisible. We have, and relatedly, moral hazard. We had some constraint on cost as a consequence of ERISA, so I mentioned the word. So ERISA allowed self-insured plans to basically get around all this troublesome state regulation, and accidentally, as you point out. And it wasn't federalism concerns that led to the demise of ERISA-governed managed care plans. It was rather consumers who didn't like their moral hazard and liked being insulated from costs. So Barak, there I disagree with you a little bit. I think there's a very voluntary rational, or maybe not rational, but irrational ignorance on the part of consumers in this. So consumers exited managed care, huge backlash. I mean, in general, I think there is, as several people have pointed out, a real objection, maybe this is related to therapeutic individualism, to any sort of either private sector or public sector control over decision-making, except to the extent that we want the folks to pay for it, which is why, getting the government out of Medicare is such a resonant theme. So I think that at the end of the day, part of the problem, so we have a supply side that's very disconnected from the demand side, in part because of moral hazard, in part because of therapeutic individualism, but I think, I do wonder whether federalism plays a role in this as well. Towards the end of the paper, you're sanguine about cooperative federalism in this context. And I'm just wondering whether federalism adds to the disconnect, because on the supply side, we have a very central federal role. On the demand side, less so, but the federal government ultimately pays the bill. So does federalism add to the reasons why we haven't been able to get our healthcare system under control because of the disconnect between the supply and the demand side?
Great. All right, well, it's a very rich array of topics and comments and thoughts, and we're open to even more if you want to take us in a new direction, but there's plenty of directions to pursue in our remaining 17 minutes. And so look for questions, and I promised I would look Clark's way first, but he's not raising his hand. You want to say something, Clark?
Well,
Clark Haverhurst, if anybody doesn't know.
But the tax subsidy has always seemed to me to be the heart of nearly all our problems. And the reasons are, as Barak was indicating, that it tends to hide costs from the consumer voter. And I think it has huge political consequences that people, the ready acceptance by the populace in general of a profession-dominated system where nobody, no government, no corporate entity can interfere between the patient and the doctor, is, I think, largely a result of people not counting costs. And they don't count costs when they're buying their insurance. They don't know they're paying the cost. They don't consider costs when they're voting for a politician who promises to regulate HMOs out of existence or take away any of their ability to try to give people value for the money that they're actually putting in, even though they don't know it. And this, I've tried to get political scientists to tell me why I'm wrong, and I think there's room here for some interesting empirical work. If you could find people with different kinds of coverage and test their opinions about some of these large issues, you might learn something. At any rate, I'd like to see more work on that subject, but I think it is very much a part of the foundation on which this consensus that I think that your paper apparently finds, that really doctors and patients should make the choices and nobody else should interfere. I think that is very much based on the notion that consumers have been lulled into thinking that somebody else is paying and not themselves, and that is huge. It also explains to me the glacial pace of reform. We would have had, well, put it this way, in every other Western country, the trade unions led the fight for universal coverage, and they got it early on. In the U.S., the labor unions, in my view, always gave lip service to the need for national health insurance or something. But I think they never really wanted it, because union leaders just love negotiating really good benefit packages, health benefits, for their workers and saying, look what I got for you. And of course, the workers are paying for it but don't know it. And that's a wonderful world to live in. And our politicians and our labor unions and our employers are all playing that game. They are promising these wonderful things with no corporate interference to people who don't realize what their stake is in that deal. And I think that's huge. But on the other hand, it's just a hypothesis. I'd like to wish someone would test it someday. At any rate, that's on the tax subsidy. I think it would have been real easy for Congress to have gone more the Republican way and saying, we're going to give you offer a tax credit to people who use it to buy insurance. If they don't buy insurance, they don't get it. That would be much more consistent with my view of property rights, liberty, and so on. And I would like to have like to go back to the drawing board, in fact, and maybe the Supreme Court can find a way to do it right.
Interesting, the ACA does deal with the hidden aspect of the tax subsidy by requiring employers to disclose on your paycheck how much the employer is paying toward your health insurance.
W-2 will tell you.
But of course,
will tell you, it's your W-2. It will finally tell you how much the employer pays, but it won't say that.
no, it tells you how much came out of yours. It doesn't tell you what the employer paid. But anyway, I'll just take a quick glance at hands around the room. Okay, so I'll start here with Mark, yeah. Okay, all right, Steve.
Well, I just have a quick question. So, first, would it be necessary if we were going to get rid of the tax subsidy to, raise taxes on your health care in the way that it was sort of demagogued during the 08 campaign, or could you just sort of give somebody a, deduction for the first $12,000 of their paycheck, and if they're using that for health care, then that's great. And if not, they get the money, which would, presumably have the same, affect the margin, but would show you, what you're spending on. The second question I have is, I am very sympathetic to the idea that the tax subsidy is at the root of this, but when I propose this to people, they say, are you really saying it will go into the operating room and everything will have a price tag on it? And so I guess what I'm wondering is if you guys could describe the process by which eliminating the tax subsidy would end up in a world where actual care is delivered more efficiently.
So, I don't see any reason why there needs to be a connection between eliminating the tax subsidy and eliminating insurance. You're suggesting that we'd eliminate the tax. Nothing would. So, are you suggesting that everything would have a price tag on it and people would be paying out of pocket?
Yeah, what I'm saying is that I have difficulty explaining to people why being more price sensitive at the insurance stage will result in less costly services being consumed at the doctor stage.
Can I try? Let me take a quick crack at that. Is that insurance companies are going to have, in the past have, and in the future will more decidedly have different degrees of both manners in which they pay their physicians and manners in which they control physicians' practice, either utilization review or capitation, and we would expect, and there is evidence that companies that tightly manage care or companies that capitate physicians do achieve cost savings, so that they could offer, if you're picking from a menu of insurance products at your job, and it's accurately priced and disclosed, you might choose the HMO option. Studies show that people are pretty happy with their HMOs. Studies show that HMOs save money. It's just that they have a very negative kind of political and vernacular valence. But people in HMOs are reasonably happy with the quality of their care, and they pay less.
There are also these things called health savings accounts, but let's not go there right now. But
can I say just one quick thing? In defense of the tax subsidy, which I haven't heard yet, the thing that was good about it at the time was that we needed some mechanism for aggregating people along a dimension that was irrelevant to their health status in order to purchase insurance. So you need to pool people in a way that doesn't contribute to adverse selection and get all the sick people in the same pool and all the healthy people in the same pool to buy insurance, and offer sick people and healthy people together one insurance product in order to make risk rating possible and efficient. And employer groups were one way of doing that during this World War II time when the tax subsidy came into, the tax deduction came into place. With ACA exchanges, that will become less necessary, although of course we've got gold, silver, and platinum plans or whatever. So there will be some problems of adverse selection within the exchange pools, but they'll be significantly less than on the individual market. And I do think that the ACA allows for the market to shift people from employer-sponsored insurance into exchange-based insurance, and thereby to get rid of the tax subsidy gradually over time if the exchanges perform better than employer-sponsored insurance. So we sort of did put ourselves on that path, and we'll have to see whether it plays out well. And of course, assuming the statute doesn't get invalidated wholesale, we might get there.
Ernie?
So we started out the morning with the constitutional challenges are easy, and we're ending up with the constitutional challenges are irrelevant and dumb.
Certainly dumb.
And so I feel like I need to say something in defense of my discipline. I mean, it's an important aspect of American constitutionalism that it entrenches certain principles against easy constitutional change. And what entrenchment means is that you don't necessarily get to do what you think the smart thing to do is at the moment. You might have to do something that you think is by definition dumber, because that's not what you'd otherwise decide to do, because it's in the Constitution, right? And there have been times in our history where we've kind of told the court to get out of the way, and the court has gotten out of the way in order to do what the smart people said that we needed to do for the good of the country. And sometimes those were things we needed to do for national security reasons. Sometimes those were things we needed to do because we were having influxes of dangerous immigrants. They're not particularly proud episodes in our history. And so I think you can have an intelligent discussion about healthcare policy. And I think it actually would inform the constitutional debate in really important ways, because I think Ted's absolutely right to say that there are a lot of really interesting federalism issues in the interstices of this statute, and they may in the long run end up being more important, but they will be important in part because they also implicate these entrenched constitutional values. So I'm just kind of, I guess this is a counter rant. I'm protesting the suggestion that the constitutional issues are irrelevant. They structure our policy discussions, and they're always there, and that's part of what makes this American.
Well, can I answer that?
Yeah, you want to.
So, Ernie's clearly going to win this debate, and he's going to be talking about the Constitution all the while he doesn't have any Medicare. And actually, the country's probably going to get, and we're going to have a marginal tax rate of about 49%, so we can actually continue on the entitlement rant. Three things. First of all, I would never submit to the proposition that this was done by smart people and we have to enact it. Actually, I think there are smart people on both sides of the debate, and I'd rather talk about what the solution is. The second thing is, I don't think this is the solution to our healthcare problems. But if this is unconstitutional, then I fear that whatever the solution to our healthcare problems is will also be unconstitutional. And I say that with some kind of confidence because I think I do know what our solution to healthcare problems are. It's the bill that I would write. The third thing is this.
Time's up.
Okay.
Go ahead, 3, go.
That's okay.
No.
I can stop with that.
All right. I thought you were going to go into your bill. Sorry. No,
Mark, can I
point over 3? Yeah.
Let me give a response even within the realm of constitutional theory, which is that the trumping effect you describe, which is often performed by Article 3 courts, I would argue does and has occurred outside the courts, and I think you'd be sympathetic to this. You've written about the Constitution outside the courts. And in the healthcare area, the views of smart people have been trumped throughout the 20th century, most recently in the mid-90s with the failure of the Clinton plan, which had lots of public support. But the trumping effect took place by invocation of this traditional authority structure, and then the political consensus fell apart. So that, to me, is functionally a trumping effect, playing out very differently than the courts. But
Ted, could I just say one thing about that?
Mm-hmm.
Why is that submerged constitutionalism as opposed to just traditional interest group politics? I mean, that's one frustration I have with your paper.
There's no interest group politics in constitutional doctrine, right? So that's the flipping answer is that first of all, you're absolutely right. But think of how many areas of canonical high status constitutional law have been constructed in part, if not significant part, by interest group contestation. So I don't think it's a complete answer. So I don't want to take up too much time. I just have a fuzzy answer.
We can
this
talk
is so
offline about
durable
that.
So
we can talk.
Here, as in a very different way in the previous panel, the question of baseline is important. So Ted's argument is that there's an empirical, if not a normative question we explain is why isn't there more healthcare regulation, and the implicit baseline is what's been done in some other areas, but I can easily think of areas where there's actually less federal regulation in healthcare, education, big area like that, crime control, most control, violent crime is conducted at the state level, even though there's certainly spillover effects, collective action problems, et cetera. And obviously, if you look at the activity of the federal government, especially on the spending side, they do actually do a lot of healthcare stuff. I think Medicare and Medicaid are two of the four largest items in the federal budget. I think the federal government, if I recall correctly, spends about a third of all the healthcare spending in the United States. There's less activity on the regulatory front, but even there, the activity that exists is quite substantial. Now, maybe the mystery is, well, the way this regulatory activity is distributed, so there's less direct intervention in what doctors do with patients, but there's actually a number of other examples we can point to, sort of a subsidized or regulated profession where nonetheless there's a lot of direct autonomy or self-regulation or whatnot. The legal profession, obviously, is a good example of this. It's mostly state subsidization rather than federal, but so it seems to me that depending on what the baseline is, there may be less of an empirical mystery here than you suggest. Very small comment. People have discussed the tax, the tax exemption for health insurance. In the 2008 campaign, John McCain actually proposed getting rid of this, and haven't studied the public opinion polling on this, but I think the general perception is that McCain did not do well in the public relations battle here. That Barack Obama put up some ads saying like they're going to tax healthcare and that's bad, and I don't think that's the only or the main reason why Obama won the election, but it certainly. This proposal certainly didn't help McCain politically, and people might propose it in the future. By the way, I think McCain, not a big fan of McCain, he was probably right about this issue, but his experience is one that other politicians may not want to repeat. That's just a small comment on.
Was there a hand here in the middle? All right.
He was right on this issue.
Oh, you want to jump in on this? All right.
Yeah, I don't want to answer long. I think it's hard to answer that question briefly, though. I just think that, let me just say, first let's talk afterwards, but also I think that, you kind of line up the range of federal regulatory activity from the New Deal forward. They've regulated fairly lightly on the actual practice of medicine. Less so even than I think the teacher in the classroom after No Child Left Behind.
Neil, you get the last word because it goes to you after this.
Well, I commend this panel in accomplishing something that's not so easy to do, which is being sufficiently provocative that you produce agreement between Ernie and me. So, I realize now that I've made substantial progress since law school, right? Because now I've been told that what I do is either almost entirely or essentially, there's some kind of qualification before the word irrelevant, whereas in federal courts, right, everything I said produced a response from the professor, irrelevant. I thought my name had been changed to irrelevant. I'm making progress. I do, and by the way, I think Barak answers Arti's question about relevance, right? If the Supreme Court, if it so happens to be the case that you've got 5 judges with the power to strike this down, which might have implications for the ability to do other things in the future that you might think would solve the problem, then it probably makes sense for very smart people to spend their time thinking about whether the court ought to do that. I do want to resist the idea that what makes overwhelming sense from a functional perspective, which is what Abby called it, is really a separate conversation from what the Constitution, properly construed, ought to allow. Right? This is not just economics talking. This is Chief Justice Marshall. Right? The Constitution intended to endure for ages to come, to be adapted to the various crises of human affairs. What kind of Constitution ought to obtain our allegiance if it disables us from solving a massive, potentially bankrupting economic and social problem? The thrust of collective action federalism is to provide a functional account that's also a constitutional account. You may like it, you may reject it, but it still seems to me asking the question of what kinds of problems does it make sense for the federal government to have the power to address? What kind of problems does it make sense for the state to have the power to address? It's not just a policy question, it's a constitutional question, and so these kinds of health policy debates are going to be implicated in the constitutional debates as well.
So let me just say that I was being excessively glib by saying it was irrelevant. You're absolutely right. That it's extremely relevant for purposes of future legislation. I think this particular piece of legislation is not going to solve any of our problems. So, but for future legislation, yes, it's extremely relevant.
I just want to say one very quick thing to that, which is that I want to draw a distinction between where I think the Constitution comes into play being where the states are incapable of fixing a problem versus where I think that functional federalism could argue that the federal government would do better, but the states are not incompetent, right? And so I would draw a different line. I would say, for myself, I would say functional federalism suggests that the federal government will do a significantly better job of doing healthcare than the states. That doesn't necessarily mean that the states are not capable of doing it or that the problems of state regulation are so severe as to push us into a Virginia Plan 6 world.
That's what I mean by incompetence, and that's what the Virginia Plan. Right, we managed to win the revolution without a central government, but we came close to losing.
Well, but it may be true, if you push it too far, it may be true that absolutely every single regulatory regime is more efficient when done at the federal level, because then we just have to have only one government instead of 51 governments, and that's better, right? And so it's just a question of where's the stopping point in how much you'll allow efficiency and function to take you away from the basic structure of federalism.
Let me thank our panel and our one-paper writer especially.
Thank you all.
Boy, you got me through red meat.
My gratitude, as well as the gratitude of the authors, to the editors of Law and Contemporary Problems, who are very eager to bring these papers to publication. We are all especially indebted to Dana Norvell of Duke Law School's program. She ensured that everyone got here. She ensured that everyone had a nice place to sleep and good food to eat. She made this happen. I don't know what would have happened if I was charged with discharging her responsibilities. I want to thank our Dean, David Levy. As always, he's unwavering in his support for worthwhile intellectual endeavors at Duke Law School, including those of simultaneous significance to members of the bench, the bar, and the academy. And finally, I want to acknowledge Rick Horvitz, Duke Law class of 1978. His profound generosity makes possible the program in public law, which in turn makes possible projects like this one. So thank you all, and I hope you found your time at Duke a rewarding and enjoyable one.
Thank you.
Produced by Duke University. Online at duke.edu.